Well, hello, welcome to our webinar, Everything You Wanted to Know About Third-Party Funding in the US, but were afraid to ask. Look, I'm going to be really brief in my introductions as we've got a very packed panel and a lot to get through. And as you can imagine, we will be giving you an expert take on third-party funding, assisted by what I think is one of the most impressive casts of speakers we've ever assembled together. I'll give each of them an almost heretically brief introduction, but I'm sure you'll sympathize with how difficult this is. Really, I could spend a good 10 minutes describing each one of them and outlining their experience in the field. So firstly, we are delighted to be partnering with Omni Bridgeway, which, as I'm sure everyone knows, Omni's been involved in third-party funding for many years under its various incarnations. I think this year marks the 35-year anniversary for at least for the founding entity of Omni, with various milestones along the way, including a decade servicing the US market. And they are, by any measure, in the elite bracket of funders. And we're very pleased to be joined, and for this discussion, led by Matt Harrison, who is Senior Investment Manager and Director of Complex Strategies for the US at Omni. Matt is responsible for Omni Bridgeway's San Francisco Bay Area operations, which he launched in 2015. Prior to joining Omni, Matt spent 15 years as a litigation associate and partner at Latham & Watkins, where his practice focused on representing clients in a variety of securities and M&A litigation matters. We'll be hearing from Matt in just a moment, but I'll introduce the rest of our speakers first. So, look, in any discussion of third-party funding, it's always good to hear what in-house counsel think. So we are especially pleased to be joined by Effie Silva, who is Global Ethics and Compliance Leader at Cargill. Effie is an accomplished arbitrator and fellow of the Chartered Institute of Arbitrators with corporate legal executive experience at Fortune 100 public and private global corporations and nearly 2 decades of private practice experience at top global law firms. Before joining Cargill, Effie was a senior member of the legal team with Tyson Foods, and before that she was a partner at Duane Morris and McDermott, Will and Emery. And before that she was a senior attorney at Baker McKenzie, and in all of those roles she represented parties in international and domestic arbitration and litigation disputes. So Effie, do you want to say a quick hello so people can see you?
Yeah, hello everyone. Thank you for that kind introduction.
Oh, as well, thank you for joining us. Well, we are also joined by perhaps one of the most experienced cognoscenti in the funding space, Mr. Roman Silberfeld, who is a partner with Robbins Kaplan and also president of the International Academy of Trial Lawyers. Roman, as I'm sure everyone knows, has an impressive record of courtroom success across many challenging disciplines in the field of complex civil litigation. He gained national recognition for his role as the lead trial counsel in a litigation brought on behalf of the client Salador International, creator of Who Wants to Be a Millionaire? The case's verdict, which I believe is the largest verdict ever obtained in a Hollywood accounting lawsuit, still to this day, Roman. In addition, he has repeatedly served as the court-appointed lead counsel and chair of court-appointed litigation committees in multi-party complex litigation. So, Roman, do you want to say a quick hello?
Morning, everybody. Great to be with you.
So, thanks for joining. Okay, well, lawyers are famous for their robust constitutions, but I believe that our next speaker, Luan Tran, a partner with King & Spalding, might be one of the most robust in the business. Luan has been answering emails at a range of times that suggests he never sleeps. He has over 20 years of experience in international arbitration and is among the few first chair trial and arbitration lawyers with an active US and Southeast Asian practice, hence presumably the lack of sleep. In addition to his international arbitration experience, Luan is recognized as a leading attorney in ownership and partnership disputes with co-founders of technology companies. In a profile of his work in a co-founder lawsuit, Forbes magazine called him the go-to lawyer in this area. So Luan, do you want to say a quick hello? Thank you for having me. Hello. Excellent. We are also joined by Mark Litvak, an intellectual property partner with Pillsbury, Winthrop, Shaw and Pittman. Mark is an accomplished litigator with experience in trademark, copyright, and general commercial cases from New York to California and from Florida to Washington. He has won jury verdicts defending multi-million-dollar claims and has won 8-figure jury verdicts from plaintiff corporate clients. As lead counsel, Mark has successfully defended numerous multi-million-dollar class action lawsuits across various industries. Mark, do you want to say a quick hello?
No, good morning, James, and thank you, and welcome to everybody.
Excellent. Well, moving on, we're also joined by Stephen Cherney, who is a partner in Quinn Emanuel's Boston and New York offices, and I believe a former chair of the global IP group at Kirkland. Steve has been lead counsel in numerous high-profile patent cases spanning technologies, including medical devices, pharmaceuticals, telecommunications, electronics, financial and business methods, and consumer products. He has been twice named as Litigator of the Week by American Lawyer. It's also worth noting that he has won some of the most important patent cases of the last decade and holds the record, I believe still to this day, for the largest ever recovery in a patent or patent case of more than $2 billion. Steve, do you want to say a quick hello?
Hello.
Excellent. Short of the sweet. Excellent. And last but by no means least, we are joined by Robertson Coonagan, a partner at Fenwick & West. Robert is a formidable courtroom advocate, as well as an advisor to life sciences companies of all sizes as they prepare for product launch, anticipate generic or biosimilar competition, and navigate all manner of business conflicts. He has been recognized for patent litigation by the Legal 500 and is regularly recognized by other lesser legal media titles. I'm not sure if Robert has joined us. If he has, Robert, do you want to say a quick hello? You have. Excellent. I can see you there.
I'm here. Sorry to be a bit late. Pleasure to be here.
Worries. Thank you for joining. Okay, well, with that and conscious of time, I will hand over to Matt, who will get us underway. Matt.
Thanks, James. And thanks to everyone who's attending, and thanks to the panel. I echo James's sentiments about the makeup of this panel. It's probably the most impressive group of folks I've been asked to speak with. And I do invite them all to jump in if they have a salient point or something interesting. I'd like to make this a free-flowing discussion, but at the beginning, for the folks in the audience who may not know much about what litigation funding is, which I certainly didn't when I was offered this role 6 years ago, let me run down a few key issues that we'll dig into as we go through. So the baseline question is, what is litigation funding? It's non-recourse financing to support meritorious litigation in exchange for a portion of the proceeds, if any. The thing that has changed the most since I started 6 years ago is the makeup of who's seeking litigation funding for cases. And by that, I mean, initially for me and for the industry, I think it was more of a David versus Goliath proposition, and access to courts, access to justice. And there's still a lot of that. We get a lot of inquiries involving inventors and smaller companies that are afraid that they're going to get outspent, which is a big issue in our legal system. But the shift for me that I've seen is that a lot of large companies as well have now turned to litigation funders for assistance. And that's because at bottom, what litigation finance is a risk mitigation tool, whether it's for the law firm who's taking risk on a contingency, or the company that doesn't want to pay the lawyers, which I have a lot of experience with, having worked at a big firm for 15 years, or wants to take on litigation, but not take on the full risk in exchange for some of the upside. I want to be clear that we're talking about commercial litigation funding instead of consumer. There are two different flavors. There's quite a few different flavors, but those are sort of the big categories. And we're talking about complex commercial IP litigation, international arbitrations, very large, complex cases where the parties are represented by competent counsel, as opposed to small, say, personal injury cases where the individual is selling his or her claim without representation, and usually it's a very small case, like a personal injury type case. But in that in that regard, the types of cases we see are, anything that's complex, any civil case, like a breach of contract case is our wheelhouse, but we do a ton of antitrust, patent cases, soft IP, international arbitrations, judgment enforcement, you name it. I think the list of things that we don't do in this industry is much smaller than the things that we do. And those would include things like, as I mentioned, personal injury and defamation, things like that. In terms of arrangements, there are quite a few different arrangements that funders do. And it's kind of a fun industry because it's a bespoke area in that you can tailor the funding to whatever the client or the law firm needs. So for example, we fund single cases. We fund portfolios of cases, both for law firms and for companies that have multiple cases. We monetize awards for appeals. We sometimes purchase judgments. We engage in judgment enforcement and things like that. So it's a very broad range of products that are offered in the industry that people can take advantage of. In that space, and more relating to the single case part of this, funders typically cover fees, a portion of fees usually. They like to see that the law firm's taking some risk, so we can align interests and make sure that everyone has skin in the game. Costs is a big one. Even if the law firm is on a full contingency, a lot of times the funder will cover the cost of litigation. Working capital to keep the company afloat during the course of the litigation, which often can be 5 years or more. And even existing obligations that the company or the law firm has, pay those off, get them back to zero, and then move forward with the case. Briefly, how do funders get paid? It's, as I mentioned, it's non-recourse, which means that if the case loses, then the funder doesn't get anything. The merits have to be very strong, as you can imagine. And we'll get into a little bit of the due diligence process that funders go through. And it's very rigorous, at least for most funders, for reputable funders, our contemporaries. And we need to make sure that the case has strong merits. Funders are typically paid back by way of a multiple or a percentage or both, a greater of one of those things. And it usually increases over time. The more money that's put out, the more the returns increase. In terms of how funders look at cases, I would say that we, I can't speak for others, but we see about 1 to 1.5 cases per day, in terms of like the sheer numbers, which is a lot, right? But the fact is that most funders, and we reject 95% of the cases we look at for many different reasons. And a lot of them just don't fit the funding mold. The merits may not be strong. The damages might not be sufficient to get the funder its return or the claimant anything after the funding, which we'll talk about a little bit. It might not be in the correct area of law for commercial litigation funding, at which point we'd refer it to someone else in a different industry. It might not be big enough for an investment. Our minimum, and a lot of the company's minimums out there are about $1 million, although the average is much, much higher than that, because these things take a lot of time, and there's an opportunity cost as well. Some other reasons that the claimant may lack integrity, that's a huge issue. You got to make sure that you're going to get paid at the end of the day, and that that there's not going to be any impediments to that. You want to make sure that the contract you have with the claimant, they're going to stick to that contract. And sometimes it doesn't happen, but luckily, if you do your vetting in advance, you got to make sure that's probably going to happen. Sometimes the lawyers aren't a good fit. Sometimes it's not permitted in the jurisdiction we're looking at, which is rare, but it still happens. Sometimes you can't agree to terms. Sometimes the lawyers won't take a significant amount of risk. Those are some of the reasons why we reject cases, and the reason why our rate's so high. I will say that when cases come through firms like, that are represented on this panel, the acceptance rate is much higher than say a cold call, because we know that the lawyers who understand litigation finance and understand what funders are looking for, they bring us cases that have already been pre-vetted, and they understand what the dynamic is. Um, I think just briefly, a couple other things. Obviously, when we look at cases, the types of cases we look at are the opposite of what I just said. Strong merits, sufficient proceeds, strong lawyers, claimant that has integrity. But there are also some intangibles. We look for a good story. We want to be wearing the white hat. We want to go in with a good story for the jury. Often it's very helpful for us and for our investment committee to know that we're helping someone, right? Someone that to right a wrong. That's very important to us. And then, of course, if it's a smaller claimant, an individual or a small company, that the access to justice comes in. How are we going to get this person their day in court, or this small company against the big guys? I could go on for a full hour on this, but I don't want to take any more time. There are other issues that we will get to throughout this thing, but I want to turn it over to our other esteemed panelists. Let's start with Roman, who I understand has a deep experience in this area from many different sides. So I do want to get a sense from you, Roman, what your background is, your experience with funding, and also, if you have any views on the relationship between, it's an interesting relationship. It's a tripartite relationship when you're doing a single case. Sometimes you fund law firms where it's just the two parties, but I want to get a sense for your views on how that relationship works and your view on whether it works well.
Sure. It is a more complex relationship than simply lawyer-client because there's a third party involved, namely the funder. I was sort of there at the beginning, Matt, when Omni's predecessor, Bentham, came to the United States, and I sort of stumbled across some of the people who were then at Bentham, who have now sort of moved on. And I've worn, several hats over the course of the years, both representing funders, working on cases that were funded, dealing with legal issues that arose out of not necessarily failed, but at least contentious funding agreements. And I think what I take away from all of that, not to occupy the conversation too long, but my takeaway is that the best relationships are the ones where there is really good alignment between the interests of the client, which have to be primary from my perspective as counsel, the interest of the law firm, because selfishly, last time I looked, I was not a nonprofit, and obviously the interest of the funder. So aligning those various interests in the right way and balancing them such that everybody feels like it's fair, that's the knack. And I know Omni does that particularly well. Others do as well. Other funders do as well. But my experience is Omni does that particularly well, such that there are good outcomes. You are helping people who need the help, and if you make the right decisions about what to fund, then there's plenty of dough left at the end to pay your take, to pay the lawyers, and leave plenty for the client, so that the client feels like they got their day in court and a sense of justice. So to me, the key theme here is how to align and balance those interests, and do it, by the way, not just for the day that the litigation funding agreement is signed, but through the life of the agreement, which sometimes can take 3-4 years and maybe longer. You're muted.
Yeah, technology. One thing you touched on, Roman, was fairness and aligning of interest. Have you seen I'm guessing that you've talked to many funders throughout your career. Have you seen a wide disparity in the way that funders approach the relationship?
Oh,
sure. And if you're advising a client on how to choose a funder, what sort of things do you look for?
Well, and it's interesting. Yes, I have seen a wide array of terms, candidly, from fair all the way out to confiscatory. And I obviously counsel people against the confiscatory, end of the spectrum. But it's funny, you said something interesting to me, that the integrity of the client matters. And obviously the integrity of the law firm that you deal with matters too. What I tell people is measure and gauge the integrity of the funder as well. If the funder is looking to take an undue piece of the recovery, that is a red flag. And I tell clients all the time, be careful of that. So that's, at least one thing that could be said about that, but I'm sure other panelists have other experiences too.
Well, let me ask Mark. So when I want to talk a little bit about a similar topic, which is determining when funding is right and when it's right for a particular case and a particular client, and what sort of decision-making process you go through when a client approaches you about funding, and also how that involves your firm and perhaps your executive committee or contingency committee who's making the decision on that.
Yeah, no. One is you need to look at the return, and that is, will the likelihood of a return, given the expenses of the litigation, warrant funding? That is basically when we're going to go to a funder, I recognize that a funder wants to see basically a 10x, usually in my experience, a 10x possibility. That is, if I'm going to have a case where I'm going to have a $10 million budget, I should be ready to have a $100 million return. And that is, if I have a case with a $10 million budget and I'm going to have a $20 million return, I'll talk to the client and say, look, this doesn't pay to waste the funder's time. There's not the return for the funder there. So, and the other thing funding is expensive, as you pointed out, Matt, and it's expensive from day one. So you want to look to determine what is the likelihood of out strategies. So if I believe I can settle a case relatively quickly, and by relatively quickly, phone calls, doing something along those lines, funding's probably not the way to go because the cost of that is too high for the client or for the firm. But if I think I have a path where I'm going to be in it for a while, and I think, Roman, you said these things go on for 3 years, 4 years, 5 years, and as you and I get older, they seem to be taking longer. You got to be prepared for the long run, and you need to see paths and exit strategies for it. The other thing, and you said it, Roman said it, you need to have a client who's aligned with interests with you and your funder. For the most part, and I think Roman, once again, I'll steal from you, said we are in a business. If a client is doing this for the economics, it's easy for us all to deal with. If a client is attempting to send a quote message, messages can have costs that don't work well with funding. And I want to align with the client from the get-go and understand if this is a business and economic decision for you, then we can all align. I can align with my firm's interests. I can align with the funder's interests. But if you are in this to deliver a message to put pain on the defendant, well, that may mean can often be non-economic and is not in the funder's interest and may not be in my firm's interest, especially when, frankly, the client's really not paying anything to inflict that additional pain they look to do. And thus you need to understand what is your client's goal here. And there are clients, we've all dealt with them, who want to punish the other side. And that becomes somewhat problematic to the firm because the client's not paying for it and for the funder.
Right. Yeah, and from a funder perspective, I'll add, Mark, that I think expectations are huge, right? You have to know what the party's expectations are from the beginning. And I would counsel anyone considering funding to make sure they understand what each party is in it for. The transparency aspect of it. What is the funder going to get at the end of the day, or actually under every scenario? Let's figure it out. What they're going to get two years from now versus 5 years from now, and what the funder and the law firm who's taking risk needs to figure out what the party's motivation is. If the party's motivation is to inflict pain versus getting a monetary judgment, then that case is probably hardwired for trial, right? And as we know, even with the fantastic lawyers on this panel, trial is, especially in front of a jury, is often a roll of the dice, right? You can have the best facts, the best lawyers, you can have secured victories throughout the entire case, and then get to trial, and some of it goes out the door, right? Because you never know what the jury's going to do. Mark, on the back to the point on clients coming to you about it, do clients ever ask tough questions like, and I think you brought it up, which is the cost of capital is high. Like, why is it so high? Why shouldn't I get a different funding source? What are we doing here? Why don't you do a full contingency for me? Things like that. Do you get questions like that?
Sure, we do. And we'll start with, you can go to a bank and borrow money at a lot lower cost, but I will promise you it will not be non-recourse. And that is, they are sharing the risk with you. And you need to understand there's real risk here. And the longer the case goes on, the dollars at risk go up significantly. And one of the things you mentioned, that is, to me, the most expensive part on a per day basis is what I call trial, which includes that final pre-trial, when you're really going, it's no longer, 40 hours a week, it's 60 hours a week for the trial and that pre-trial. That's a very high percentage of the cost of the matter. It also tends to be delayed several years. And as you pointed out, the funding gets more expensive just by the nature of time. So you want to align quickly and say to a client, what is your goal here? We're doing some now where from the get-go, we sit down with the client and say, good, let's agree on what exit strategies we have. What economic return are you looking for? The clients recognize the money's expensive. If they don't, I tell them that, because they need to understand your concept of an 8%, whatever, you can go borrow on a home at 3.5% for 30 years, but this isn't that. This is a share of a risk. And if they say to me, why does the firm not want it? That is, I'm willing to take risk. But like most people, I should diversify my risk and sell part of my risk. And that's why we deal with funders. It also, and it's something you alluded to earlier, when you have a good relationship with a funder, when I have something with Omni, and most of mine is with Fiona, Cheney, whatever, I'll pick up the call and say, look, tell me what I'm missing here. And it becomes a shared sort of, because we're going to share this risk together, or Jim Batson, who's more than willing to share where I miss risk. And I appreciate that. So you all want to be aligned with your expectations and your understanding, because when a client tells me, or one of my partners tells me, because I'm on our funding committee, this is a sure winner. That just means you haven't tried enough cases, because there's no sure winner. There may be sure losers, but I haven't seen it. I haven't gotten a case yet that's a sure winner.
Yeah. Well, on that note, I want to turn to Steve. Mark touched a little bit on the underwriting process in that, tell me what's wrong with this case. And Steve, I want to get your views on that process and whether you think it's beneficial. I know that as a funder, sometimes people are like, wait a minute, like you need 30 days to review this case, like that's a long time. And we say we need all that time, right? For many different reasons. And I wanted to get your thoughts on that and whether you think it's beneficial, because there's a lot of money out there right now in this industry, and just your thoughts on how that process goes.
Okay. First of all, I want to say that all my cases are short winners, but that's just for everybody on the viewing public. But but one of the things I found that surprisingly, the more I've been involved with funders, good funders, and that is Omni and other funders who are rigorous, is that there is a benefit from the underwriting process that I didn't anticipate, which is, when you're thinking about a contingent fee case, part of the problem, of course, is you have to bear all the risk, and it skews your incentives a little bit, because at that point you're going in the hole, and you are incentivized to spend 10 hours to get $1 million, as opposed to paying putting more time in, because the funder is helping you hedge the risk. And as part of that process is that when you're dealing with the funder, that when the funder starts underwriting it and is looking at it just as purely as an investment, I found that they are more rigorous than lawyers are. So as an example, when one of my partners comes to me and talks to me about a contingent fee case, there's an emotional aspect to it. There is an aspect of, oh, I think this is a great case, we should take it on, I think this is a winner, all the things that people say. And, you know, it's sometimes it's hard to respond to your partners who you want to mollify. And also you're viewing it a little bit as a lawyer and a little bit less as a business person. I found that the more I deal with funders, the better decisions I make and my firm makes in terms of what risks we should take on, because we're sharing them. I find that funders are more dispassionate. They're not thinking about, I very rarely have found them to care about my feelings, although they care a little bit. I mean, they're not trying to mollify me or make me feel good about the latest great case that I think is a sure winner. They're just looking at it in terms, and they want me to show them in a way that even the most rigorous internal law firm committees, I don't think does. They want me to show them why it is I think that it's a winner from a liability perspective, but also, and this goes back to something I think Mark said, which is, why will this cover it? Because, you know, it's easy to look at a case and, you know, I'm a patent litigator. I say, oh my God, infringement's certain. Look at this. And validity, these patents are great. And then stop there and not think about what's the real chances of getting enough money to cover the investment of time for, you know, our time or the money. But the litigation funders are, you know, the good ones are uniformly very rigorous. They put us through our paces. And what's actually happened is that we often start reflecting and relying on that process in a way that I find to be very collaborative and cooperative. We're aligned, as Roman said, our interests are aligned. And then I had a case recently where we had come to a conclusion that we were going to take it on in some form of contingent fee basis, you know, a hybrid with a funder. And then after that decision had been reached, we were working with the funder, and the funder started saying, well, I think we should have term X in here to guard our interests. And we think that you as the firm should adopt that as well, so that our interests stay aligned. And as a result, by the time we got through the process, the firm's interests were more protected. I think that we had done a much better job in terms of assessing. I think another thing that the funders are great at is coming up with creative ways to have off ramps or times that are very rigorous as to when we should reevaluate the case. I mean, when I was younger, you know, you take on a case like a contingent fee case, and you take it on as like it was almost digital. Okay, now I'm in the case, and you didn't think about, okay, we should be talking about this at this point as to whether we should continue. I now find that the more sensible funders will say, okay, we'll free up X amount of dollars until this period, and then we need to talk. And then if it turns out that you as lawyers and we as funders don't think it makes sense, we should then take a step back. And I think it helps adjust everybody's expectations, including the clients, as to a rigorous process of evaluating the case, as opposed to just, okay, I filed the case, call me when it's over. So that's probably a long and hopefully not too confusing way of saying that I think one of the unexpected benefits of funding is the rigor that it makes lawyers apply to taking on risk. I don't think it's naturally. I think we tend to be a little bit gamblers. I think we tend to be a little bit like, oh yeah, we can win. And there's a certain amount of optimism that the funders don't share and kind of ground us. And I think we make better choices. And I think also as a result, the cases that get brought with funding are better. So, you know, there are people who think that funders are just enablers of people with cases that are not meritorious. And I think, if anything, what I've seen is that they enhance the merits of the cases being brought, because they're not being brought on emotional bases, or, as I think Mark talked about, not to bring pain to the other side, they're being brought for purely economical reasons. And if they're not meritorious or aren't justified by the amount of money to be recovered, they don't get brought. And so I think the cases actually are better, the ones that are brought with funders. So
Yeah.
hopefully that
Matt,
makes
I may follow up quickly on Steve. I totally agree with Steve, and that I think is one of the difference between a very good funder and not so good funder is their internal ability to help you assess the case. You know, the more reputable funders, they have in-house team who, you know, comprise of, you know, very sophisticated counsel, even former judges and so forth. And that's a great benefit to you in analyzing the case. Number two, I think in terms of confidentiality, sometimes you have a really good case. You don't want the funder to farm it out to an outside law firm to do the due diligence for them. You rather deal with funders who have a very sophisticated in-house team to review your case for confidentiality reason, and your client wouldn't want another law firm to look into your potential case either. So that I think is also a very key difference between a good funder and a not so good funder.
That's a good point. Thank you. And you know, for Steve and or Luan, one thing Steve touched on was the relationship after the initial underwriting due diligence process. What has been your experience with funders beyond that? Are funders, you know, micromanaging every decision? Are they checking in, you know, once every month or two? What sort of process happens after they, you know, you sign the contract and the funding begins?
was that directed to me, Matt?
Yeah, yeah.
Okay.
Go for it.
If it wasn't, I'll take it anyway.
Yeah.
Yeah, sometimes it's a little bit of micromanaging, and sometimes even with experienced funders, there is a certain amount of tension between, obviously we have access to confidential information, and so you're trying to convey to them the progress of the case and give an honest assessment, but not being able to show the evidence upon which your optimism is based. But you know, in my experience, you know, and we keep talking about the category of good funders, and I do think that there is a difference. Some funders are a little bit more fly by night, but the good ones, you know, they stay involved, they express their views, but ultimately they understand that there's a trust element to it, because part of, in my experience, of the investment is the case, but part of it is the lawyer. And because after the initial assessment, the case changes in terms of the dynamics. Discovery goes forward, especially in the United States. And, you know, you need to have a good relationship so that when the person who is funding it says, well, what's your take on the case? They've got to be able to give their input and into their views about risk, but they also have to trust that you're giving them your best honest assessment about how the case is progressing. And there's only so much micromanaging a funder can do, because the funder is not seeing most of the evidence. I will say that probably the area where funders are most interested, and maybe this will give rise to some discussion later, is discovery about funding. That's one that tends to be less about something that is confidential. You know, obviously I can't show you as a funder the documents from the other side, the code, the technical documents, the financial documents. But now that discovery of funding has become such an issue, that's where I tend to see the most, you know, micromanaging has a pejorative context, the most intense interest, and where we tend to work the most closely about decision making with the funder, because it tends to be the funder tends to have broader interests. And then I will say you have to spend a lot of time balancing the client's interests in that specific case with the funder's broader interest in how discovery impacts their business. So that's probably where most of the, other than that, I mean, maybe I'm lucky enough to work with funders, as I'm sure the other panelists are, that fund us because they largely trust our judgment. We meet regularly, we talk, we discuss the merits of the case. We have off ramps that are required to assess whether the case should go forward. But I don't view it as too much micromanaging. It's just mostly updating. So I hope that answers your question.
Yeah, it does. And I do, if we have time, I'll turn back to the discovery issue and whether, you know, clients are they want the other side to know that they have funding and whether they want stuff to get out, things like that. But I don't want to, I want to come back if we have time, but I want to turn to Effie. And you know, obviously, Effie, you have a unique perspective on this panel. You've worked at big firms, and you're currently in-house, and you have some responsibility over ethics. And I wanted to get your take on, you know, how funding perhaps helps lawyers of various types and vintages. And I want to also see if you have any views on from the in-house perspective on, you know, what your company and what other companies may view of funding as an option.
Well, two things. One is, you know, in-house counsel, we're seen as a cost center for the corporation. So in order to bring a case internally, you have a bunch of stakeholders, and you have to give really the economic reasons why this is going to win. It's almost like you have to go through the gauntlet of what a funder goes through to analyze whether to take on the burden. So I think, you know, sharing in that burden and mitigating the risk is really a smart way for corporations to go about, you know, getting their economic fairness or, you know, windfall, I would say, in whatever breach of contract case is du jour. But I think what's also really interesting is the opportunity for in-house counsel to be seen as, you know, more revenue producing, especially with, you know, in terms of COVID and the mergers and acquisitions that are happening and all the other ramifications of lost product and shifts in the supply chain. You're going to have a lot of these kind of economic-based cases coming to light, I think. So I think, you know, having a funder work with a corporation to mitigate that risk is interesting and very poignant too for diverse attorneys in-house as well as in law firms. I think, you know, as we all know, it's more difficult for women and folks of color to get ahead in law firms because of the ongoing relationships that some attorneys have, more senior attorneys have. And I think that if you need to get, you know, earn your stripes to bring a case that you could use and leverage, you know, Omni Bridgeway or the other funders, the good funders, to help you make the case to your law firm and take on. I think also as in-house counsel, switching hats here for a minute, you're able to change your outside counsel relationships based on that funding, which really can be a boon to, you know, with all in-house counsel really, you know, reaching for folks of color and women to take on their cases. I think this could be really a catalyst for in-house counsel and also outside counsel to work together and marry taking on these cases that could really make careers and make long-lasting careers in corporations. I mean, it's not a utopia. I think it's very difficult in general to have your firm or your corporation take hold of it. But I think now with the movement of DE&I as part of, you know, financial, you know, shareholder funding activists and so on and so forth, I think that the DEI perspective can be really of critical importance to corporations and to outside counsel. And I think that may be an avenue really where funding could do good for all, right? Having that story, Matt, that you discussed earlier, I think bringing in a counsel team and a funding team that shares that perspective and the importance of diversity could also really give a comprehensive view of the litigation.
Yeah, that's helpful. It's a good perspective and something you know, obviously we should think about. So I want to circle back, Effie, to you know, I understand that you do have a good grasp of some of the ethical issues, and you know, we could spend an entire day talking about ethics, but I wanted to ask you, what you think is perhaps the biggest ethical issue in this area, and get your thoughts on that.
I think it's really establishing the independence of the lawyer. I think that is the crux of all ethical issues that are of high importance. And I would, caution attorneys that, depending on what rules they have in the state, but, the ABA model of rules of professional conduct really speak to this. And you need to make sure that the attorney is not directed or regulated by the funder, that their primary duty is always to the client. And how you do that, you could do it contractually, you can do it, which is probably the safest way to do it. And also in your advice and your seeking. And I think, I don't know about the other panelists here, but you have a group of people which I'm sure have been in the crosshairs of this very issue, and preserving their independence away from the funder. And the other issue that I think is really important is the client informed at all times, right? You don't want ever a client to be in the dark about any part of or any degree of the case, and making sure that that advice is timely, is comprehensive. It involves, possible concerns about, potential conflicts, I think are all critical in the ethics realm.
Yeah, that's helpful.
Matt, if I could just add, and I'm sure I speak for the other private lawyers here, to just underscore what Effie said. The longest single paragraph in my retainer agreements is this one in a funded case. It goes on for a page and a half, single spaced, about the description of the relationship between lawyer, client, and funder, who the duties are to, my duties, who's the client, who's the decision maker, all of that, everything Effie talked about. I couldn't agree more, and I'm sure others have the same experience, but that has to be in writing. Otherwise my professional responsibility partner would fire me. It has to be in writing at all times, and it has to be clear and unmistakable. Otherwise you get into problems.
Right. Yeah, goes back to the discussion of expectations. I think they're extremely important in a relationship like this, understanding and attempting to predict what might happen, and if it does happen, then who's gonna be responsible for what, and who's got duties to whom. And sometimes it's hard to predict everything because litigation is very unpredictable, but at the same time, you want to try and make sure you're thinking about all those important issues. I want to turn to Bobby really quick, and I want to, Bobby, I know you have a unique perspective because you work with a lot of startup clients and clients in the life sciences space. And I wanted to ask you, when you're talking to clients about the decision on whether to engage in a relationship like this, what do you advise them, and what is your thinking process on whether it makes sense or not, both from the client's perspective, like whether it makes sense for the client to take on this type of capital, and also talking to your firm about whether it makes sense in a specific relationship?
Yeah, thank you, Matt. So our firm works with thousands of different startups around the world. So we have a lot, it's pretty common that in the litigation group, those clients will come to us with either a claim or they'll need to defend themselves against something. And it's pretty common that they'll say, look, we just don't have the financing to do it. So this is the kind of traditional David and Goliath situation that Matt referenced earlier. We have a discussion around what is the claim, what's the strength of it, and what is the economic outcome. And we have that very real discussion that Steve talked about, where it's, are you talking about a $100 million claim, it'll take 10 million to get there, or is it 10 million to get $12 million in a claim? So we have to have that very hard conversation. A lot of startup clients are not used to being in litigation, so they have this assumption that it's 6 months and you're done. And the reality is it's very rarely going to be even remotely close to that. It's going to be years to get there. The other big factor that we see a lot is very similar to what Effie talked about, where we'll have a startup who is financed, very well financed. You know, some life sciences startups will have hundreds of millions of dollars of financing, but their board will tell them, look, that's for R&D, that's for operations. You know, we understand you might have this claim or you perceive that you have a claim, but the money that you have, that your investors expect you to do something with it, and that is not pursue litigation unless you absolutely have to. So in that situation, like Effie mentioned, it creates an opportunity for that client to find funding, to be able to go pursue whatever it is they need to do as a business entity without affecting their other financings. We also see a lot of questions around defenses, you know, where a client might get a cease and desist letter on the eve of a big financing. And the question is, our investors don't want us to use the money on this. Like, can we pursue funding for the defense? And there we have a very hard conversation, because often when you're just simply defending, it's hard to see what the economic opportunity is. I know, Matt, you mentioned we might want to talk a little bit about like injunctions and things like that, and how creative, good funders can talk to the client and say, look, there might not be dollars that come out of the litigation outcome, but because that injunction or non-monetary remedy is of value to you, we can put our valuation on it later or in some other manner. And if you get creative, sometimes you can find situations where those claims that might not seem to have economic opportunity because they're really a defense situation, because there is clear value to the company, you might be able to figure out a way to fund that situation. But I will second what I think everyone has said at some point, which the key thing is the alignment of interests and knowing what everyone's interests are and having a real conversation around that.
Yeah, it's obviously very important. And Bobby, one thing I wanted to touch on is just how do you, I come from a firm that obviously relied heavily on the billable hour. I don't recall us doing much contingency work. And maybe this question's for other folks at the large firms that aren't plaintiffs oriented. How do you talk to the executive committee or the contingency committee at a firm that relies mostly on the billable hour and say, look, we need to take some risk here. We've got it funded. What's the equation there? How do you sell it if it's a good case?
So speaking just from my personal experience, it's about having a really good relationship with the executive committee and the operations, for us, our chief operating officer, and being able to have a candid conversation about this is what we think the risks are to the firm, this is what the opportunity is for the firm, and just really being upfront and honest about it. We don't do a lot of contingency work, kind of like your old firm, Matt. We are not used to doing lots of different funding and contingencies, but we will do it where it makes sense for the firm and it makes sense for the client. So we are moving to that point where I think we are much more comfortable doing it. But a few, 5-10 years ago, it was definitely a conversation that had to be had. That was a very detailed and a lot of back and forth. And I would also say having the funder involved in that second set of objective eyes is definitely a peace of mind for like the first couple times that the firm is looking at these opportunities, especially with reputable funders.
Well, look, thanks, Bobby. I want to talk to Luan about this a little bit, because he's in an area that international arbitration where I think funding is fairly ubiquitous as far as I know, but we'll let him tell us. And I wanted to get a sense from you, Luan. What sort of considerations that you take? What sort of things have you seen in the international arbitration world in terms of products and the use of litigation funding, and what are sort of the hot issues there?
There is no dispute that litigation funding is becoming an integral component of international arbitration. And that is due to a number of reasons. The first one is it's becoming extremely expensive to prosecute international arbitration matter, because the cases are fairly often very large, in the billions of dollars, involving fairly extensive technical issues, thus requiring some a lot of expert witnesses, which is very expensive. And also, don't forget that in international arbitration, you not only have to win the arbitration, but the key part is to enforce the award. And oftentimes you have to chase the defendant in multiple jurisdictions all over the world. So you can imagine the cost involved in doing that, undertaking that endeavor. That's why I think litigation funding is tailor-made for international arbitration. And it's becoming more and more acceptable, right? Originally, you know, the UK, US, and Australia obviously are the pioneers in litigation funding, but now you see this being used all over the world. You know, with Asia, for example, you know, Singapore and Hong Kong 2-3 years ago, they came out with new law specifically allow litigation funding in arbitration matters. And other countries are going to follow suit. The various leading international arbitral institutions also have come out with rules recently, including the ICC this year, which is probably the most prominent international arbitration institution, and also the ICDR, for example, which is the international component of the AAA. They came out with rules requiring disclosure of information regarding funding in an arbitration matter. So in short, I mean, litigation funding is here to stay, and definitely in the international context, it's becoming increasingly a key part of, you know, when you advise a client. Another interesting trend that I see is, like Effie has alluded earlier, you know, in-house department, we are seeing this as not as a profit center, right? As a cost center. So you see more and more large corporations having recourse to use litigation funding for their matters, both domestic and international. But we also see, interestingly, countries, you know, looking into litigation funding to litigate large investment disputes against, you know, investors. Because, you know, very interestingly, initially, you see a lot of funding in investor state cases where the investors would resort to litigation funding to go after the states. But now the states are getting smart and say, hey, we can do that as well, right? Not only in dispute involving commercial dispute, but also we, for example, our firms being retained and looking to funding by states who are going after the former dictators or former regime, you know, who been accused of stealing money and hiding all over the world. So I think the use of funding is widespread and it's becoming more and more acceptable worldwide.
Yeah, that makes sense. I want to pause for 1 second and just ask James how we're doing on time. I want to make sure that if there are any questions from the audience, we want to perhaps discuss those and see what we can do from here out.
I mean, I would turn that over to the panel and say, how are you guys doing on time? I mean, we do have a number of questions from the audience. If people can maybe hang on for another 10-15 minutes before we come to the questions, that would be great, because I think you have other questions for the panel, Matt.
Yeah, for sure. So Luan, you know, we were just speaking about the acceptance of litigation funding, at least in the international arbitration world. You know, what's your, you know, King & Spalding is a large law firm that I believe at least relies primarily on the billable hour, like my former firm. Have you seen a shift a little bit in receptivity to litigation funding at your firm and also, you know, across the board in the big firms?
I can tell you that, interestingly, in international arbitration matters, particularly the investor state cases, we use litigation funding a lot. So as I told you earlier, this is just becoming a new way of doing business. And I think that domestically, I think the litigation thing has changed as the way large law firms practice as well, right? I used to work at firms where, you know, we've done a lot of contingency cases. But now that, you know, with litigation funding, it decreased the risk and increased the chances a law firm will take on cases that otherwise they would not take on due to the risk factor. So I think that to answer your question, yes, in our firm, I mean, this is it's changed the whole landscape in the litigation context, both domestically and internationally.
Makes sense. One thing that we touched on earlier, and I'd go back to is, and I guess I'll open it up. One thing we see as funders is, whether or not to disclose the relationship. Obviously, from our perspective, that can open up a big can of worms, including subpoenas and discovery, attempted discovery. Although I will say that, and I think Effie, who knows this area very well, would agree with me that the case law is pretty favorable, extremely favorable for funders in terms of relevance and the work product doctrine. But sometimes the claimant wants the other side to know. Like, we have this war chest, and a lot of times I would say in most cases the other side finds out through discovery or other ways. But does anyone have a view on whether it's beneficial for it to come out or versus harmful?
I just want to say that, your question raises the idea that, there's also a third looming party here, which is PR, the media, right? Like that's why the alignment of interest is so critical, because, if the cat's out of the bag, in that sense, is that a good thing or a bad thing, right, for everyone? And I do think, Luan was talking about international arbitration. It's much more accepted outside the United States to have litigation funding. And I think it's because of, the origins of the American system. And it also may be, this PR media component. But I think ethically, I mean, it's really dependent on the state and the jurisdiction that you're bringing the case on, in terms of how much heat you get for that disclosure.
Matt, my view is the disclosure of whether funding exists or not and the terms is a sideshow. It's to be avoided at all cost. I spend a lot of time suing insurance companies. They don't tell me what they pay their lawyers either. That's sort of the analog.
Right.
I will say that, I've been dealing with this a lot lately. I do think it's a sideshow. On the whole, I don't really care that much about it as long as the judge is going to manage it in terms of presentation to the jury. Otherwise, it's, who cares? I mean, I understand the idea that someone might think, wow, these guys are well funded. Other people might be concerned. I did toy with the idea, although I haven't found a funder who was interested, that if it went far enough, that it would actually be beneficial then at that point to have the funder testify at trial as to all the reasons why they thought it was a great case, and that's why they put the money in. I ran that by one of Matt's colleagues who was not as excited about that prospect. But I figured, well, if the other side is going to push and make a whole big deal about the fact that the case is funded, why not then have them deal with someone who's very polished up on the stand explaining why they funded it? But I haven't found any funders who are interested in that. So barring that, I think by and large, it's a sideshow. Nobody seems to, I don't really want to have it discovered, but I haven't really found that I'm overwrought by the fact that if it does get discovered, I don't really know that there's a whole lot of use to it. Everybody tries to liken it to some type of measure of damages, that somehow this is an independent assessment of the damages. But most of the judges that I deal with in the patent space, I think have pretty much concluded that they might let some discovery of it go forward, but I don't think any of them would ever actually let anyone put on any testimony in court as to the funder's assessment of the case as somehow being indicative of the actual damages. So,
yeah. Mark, I see that you're off of mute, so I was going to give you the opportunity to chime in if you'd like to. Yep.
No, Matt, one of the things I noted is, and you said your firm did not do a lot of contingent work. One of the things about funding is it becomes then the hybrid, because if you budget right, you are back to sort of an hourly, you're getting paid something hourly. And hence it does allow you to align your traditional business model more with the outline of the case you're dealing with. You just need to know how to budget appropriately. which I think for those of us, myself and Steve mentioned it earlier, when you're reviewing that which your partners are doing, and Bobby, you may have it more than that, people under budget all over the place. Clients have an expectation maybe that you can budget to, it's a project. And I'm used to project funding, and this isn't going to work that way. And I will tell you, when you think it's 6 months, it will be 2 years. And then you'll be 2 months before trial, and a judge will say, I've got a criminal case, I'll see you in 8 months. And all of that unexpectedness that those of us who litigate more know we have to deal with. And every time one of my clients, I don't mean that, one of my partners comes to me with a case, they've got a case that's going to go on a hard schedule. Everything's rocket docketed, everything's certain, and you learn none of that is going to happen.
Yeah, that makes sense. Well, on that note, budgeting, I think, I'll say budgeting is an important part of this process, right? You have to try and estimate what the costs are going to be, what's going to get you to the finish line. And as we know, litigation is inherently unpredictable. So what happens when the budget is exceeded? What happens, after summary judgment, heading to trial, there's no more money. Has anyone on the panel experienced that issue?
Oh, sure. You can't deal with a firm as I do in, sitting on our contingency fee committee, being the executive partner. That happens way more than any of us would like. And this goes back, and I think everyone has said it, at the end of the day, our ethical obligation is to the client. And I'm in for a dime, I'm in for $1, I'm in for $1 million. And the point to cut the corners is not when you're getting ready for it. You're in it now, and now you got to go win because you owe that duty to your client, and you got to see it through. And if we've blown the budget, shame on us. And that's the risk we take. So if a funder agrees, I have that $10 million case and they're funding $5 million. Above that, welcome to the change in the share of the risk. My percentage of the total risk can just go up dramatically. And I know that when I start down this path.
But I've found most funders to be rational in the sense that if you get to that end point where you hit the cap, and by the way, the caps are useful to give discipline that you don't usually see in contingent fee cases. I mean, I'm sure we've all experienced, if you have a pure contingent fee case, everybody's like, wow, I'm going to bill 4,000 hours this year because no one has to pay for it. Whereas, of course, obviously, if you start bumping up into a cap, that makes people a little bit more disciplined. But, things are unpredictable and there's no assurances. But if you're getting close to trial, and in my experience, the funder thinks, look, if we can inject another 500,000 in, that guards my prior investment and is reasonable. I find that the funders are pretty rational about it. It's not just that, well, you've gotten to the end, too bad for you, because obviously, they want the incentives to be aligned. And so, there's lots of things that are written into the agreements and lots of attempts to try to ahead of time assess as many unpredictable issues. But I found that most funders, especially if you have a good relationship and there's trust between the funder and the lawyer, you can usually work out the things that happen that you didn't predict, because at the end of the day, the funder has invested money, and if adding additional money will guard their past investment, they'll do it. If it gives the wrong incentives and it just gets people to keep spending more and more without restraint, they won't. That's my experience.
I actually, because the funding, the way the funding is usually structured in the sense that the funder will get a multiple of the invested money. I actually tell my associate and fellow partners on a funded case that actually you have to be even more careful how you build your cases, because it will be very expensive money. That's something people tend to forget. It's not unlimited funds.
Yeah, Luan, that's a good point. From a funder perspective, we're always cognizant upfront, at least, about how much money we want to put out, right? And it may sound counterintuitive, but we tell claimants, like, only take as much as you need, because you're going to have to pay us back on a multiple someday, hopefully, because hopefully we win. And you don't want to make that case settlement proof, right? And you also don't want to have the client feel like wow, I paid the funders way too much on this, right? And we don't want to feel that way either. We want the case to resolve, hopefully by settlement on the merits, and have everyone feel like they got a good deal, right? And they're happy with the outcome. So a couple more questions I have, and then we can perhaps turn to the audience. But one thing that you hear about quite a bit is the settlement aspect of the relationship, and I wanted to open up to folks to discuss, what's the dynamic with funders when it comes to settlement. I could obviously tell you how we do it, but you folks have worked with, I'm sure, many different funders and have had many different experiences. So I'd like to hear what happens. Does the funder come in and negotiate on behalf of the claimant? Does the funder attend settlement conferences? What sort of dynamic is it?
I'll go first. I mean, traditionally funders understand their role, and that is they like to be informed. I think it's an ongoing relationship, so I want to keep them informed. They do not, and they are very careful, and the good ones, and Omni particularly, very careful not to oversee that relationship. They don't want to be viewed as dictating it. They don't dictate it. And they say, look, just let me know what's going on. And we usually give them that courtesy. But that's in some ways the easiest part of the relationship, because I think, as Roman said, it is so well spelled out early on, and all of us protect ourselves and the funder protects themselves. So in my experience, it becomes the easiest part of the relationship to deal with. You let them know and they don't dictate, especially the good ones.
And I would just add, sort of in the category of, for the audience's purposes, to the extent that they're considering funding for a matter or for a portfolio of matters, to underscore Mark's point, because he's exactly right. Any funder that wants to control settlement or wants to be involved, run the other way as quickly as you possibly can and stay away from those people, because that is completely contrary to the lawyer-client relationship and our ethical obligations. And it just is a corrosive element if that's what's going on. So, that's a word of warning for those in the audience, maybe.
Yeah, exactly. Yeah, those are good points. I don't know. I think, James, if there are any other questions from the audience that make sense, I think we'd be happy to address those.
Yeah, if we have time. I mean, look, obviously funding is about empowering, so let's turn to the Vox Populi. One of the questions from some of the audience, it says, and I'll just bring this up, he would be interested, he or she, not known, would be interested in hearing what Omni or any litigation fund generally sees as the biggest issue in managing costs. So costs, not fees, in litigation. So, from a funder's perspective, do costs different from the perspective of a law firm? And related to that, do the lawyers on the panel, the counsel on the panel, feel that cost management and control is different in a funded case? So maybe, Matt, you can start by addressing that, and then we'll turn it over to the counsel.
Yeah, of course. I think good funders help manage the budget. Don't micromanage or make strategy decisions about what the spend is. But and I can't speak for every funder, but we look at the budgets. We make sure that everything's on track. We want to make sure that we come in at that number or below that number that we budgeted for cost. Because again, if we exceed the budget, sometimes it throws off the amount that the client has to pay back to us. It throws off the amount that the client might get at the end. It throws off the ability to settle the case at a reasonable amount. So we definitely take a look. I feel like just like part of my prior life, we look at the bills, we analyze them, and we want to make sure that we're on track. Sometimes they're exceeded, but we want to ensure that there's enough at the end of the day to get through trial if we have to, and sometimes appeal if that's a part of the process.
Okay, excellent. I mean, I think a couple of people, particularly Steve and Mark, raised the subject of the rigor that a funder brings to a matter. So perhaps I can ask both Steve and Mark. I mean, do you think that rigor is then brought to the cost management side of things? Does a funder bring a particular rigor to the management of costs in a funded case? Mark, you're off mute, so I'll ask you.
Yeah, absolutely. And they do it at the beginning. And if, as you said, when you have that relationship with the person, the funder, they'll do it throughout. But at the beginning, and Luan probably has more experience than I do. For example, international arbitration, the costs are going to be higher because you're paying for the cost of the arbiters. And hence, you got to keep all of these factors in mind as you do it. And a good funder will sit and say to you, look, you have not built in enough. And, or look, they will ask me what experts I intend to work with to get to where I want to get to, especially if damages, which are obviously a key component, who am I working with? Have you budgeted for that? And is there money sufficient to take it to the end? And as a firm, it's sort of more important. I can write off time. All of us who are partners in a firm can write off time. I can't write off expenses.
Yeah.
Somebody's got to pay them. And hence, in my role as overseeing for the firm, at some level, you pay almost more attention to that because it is a hard cost to us that we must manage to.
And what I find is not just the rigor, it's that the funders are very good and progressively get better with experience at aligning incentives up front. So that if I was in a contingent fee or a regular hourly case and the costs for an expert come in high, I shrug my shoulders and say, well, I'm not getting any of the money out of it. And it becomes an issue between, maybe the firm and the expert, or the expert and the client. But when the incentives are aligned such that if the costs go high, that means, as I think someone alluded to earlier, there are going to be more expensive payouts to the funder, meaning that the funder has to come in and give $500,000 more. And that means that there's going to be a shifting in terms of the ultimate payout. Then everybody is incentivized properly from the get-go to keep costs. Whereas, again, I try to keep costs down as a matter of course because I want to represent my client's interests. But that's different than having the added component of, if I don't keep costs down, then there's going to be what may be a significant shift in terms of who's getting paid what at the end, so that I'm incentivized to, I better keep this down. Otherwise, either the client or myself is going to end up with less because there's going to be triple times that $500,000 paid out to the funder, when that funder didn't even want that. I mean, what the funder wants is everybody's incentives to be aligned and have it structured so that we're all behaving as rationally as possible, understanding that it may not work, but it's better than a system where there's no incentive and it's just relying upon my attention and my overall concern for the client to make sure that the numbers work out.
I'll ask Luan to jump in here because Mark mentioned the international arbitration dimensions, but Matt, also feel free to jump in with your perspective. But Luan, is a funder helpful for you in terms of cost management?
Yeah, I mean, it's helpful in a way that, they help us assess the case, at the beginning. Again, I mean, the way I look at the cost is just like the way we spend time on the case, right? Because everything that the funder pays us, either for our fees or our costs, is going to come out very expensive at the end. So that creates a natural incentive for us to keep the cost down in that regard.
Okay, and Effie, I don't know if you have any comments to add from a kind of in-house perspective. But sorry to put you on the spot.
Yeah, no. My thoughts regarding this are really back to the sideshow. I think that sometimes when you have a litigation funder that's disclosed, it actually may give more merit to bringing the case because of the scrutiny involved in evaluating the cases. That everybody's bidding on a winning horse, and I think the financiers really come into light in maybe pushing settlement once it's disclosed. I've seen that. So that's my only thought.
Okay, excellent. Look, another question maybe Matt's probably the best qualified person to address this, but it's open to everyone. Potentially interesting. Requests for funding confined to specific sectors. Are you seeing spikes in specific sectors, or is it really every part of the Fortune 100 that's coming for funding? So Matt, maybe you can start with that.
We see ups and downs, and I'll defer to Mark on one issue, which is the insurance coverage with respect to during the pandemic and following the pandemic. And then we see ups and downs in the patent world, for example. It's not confined to a specific sector, but we see, depending on what's going on in the world, we see different spikes, whether it's if there's a market, for example, in the patent world, if there's a market for licensing, then we're not going to see as much litigation, right? If there's not, then we're going to see a lot more cases. But it's cyclical, just like everything else. And it's not confined, except for the categories I mentioned before in the commercial litigation space. It's not confined to a specific sector. Like we won't do personal injury. We don't fund class actions by themselves. We don't fund discrimination type cases or things like that. But for Mark and Steve, they may, and Luann, I don't know if there's different times when international arbitrations are more prevalent than others, but I know Mark has some thoughts on the insurance.
Yeah, well, COVID clearly changed the economy and changed the game in quite a few sectors, and there are industries that were dramatically impacted by COVID, and you now have to look and see, and that has obviously become a huge area. That is, people are suing insurance companies, as Roman noted earlier, and there are hundreds literally of litigations all across America, from small mom and pop restaurants to multi-billion-dollar theme parks, movie chains that were effectively almost destroyed because of COVID. And obviously that has taken up a large amount of time as we look. My firm does policyholder only, so like Roman, we sue insurance companies, and that is sort of a flavor now we're all looking at. And also what changed that is the nature of the entities suing. People who historically may not have wanted to bring claims, universities or somebody, they were dramatically impacted by the pandemic, and still are being impacted by the pandemic, and trying to recoup some of those things, and believe they bought insurance to help them through that rainy day, and it didn't rain, it flooded, and they're now trying to deal with it. So
that break in supply chain is real, and the mergers and acquisitions post fallout, you didn't sell me the company I thought you were selling me, is real. And I'm seeing a lot of that internally, and speaking to other in-house counsel regarding post-acquisition fallout and shareholder suits. So I'm sure that you all are seeing that too in the funding space.
And in the international context, you see more and more cases filed in developing countries, especially in Asia, Latin America, where, as the economies expanded, there are more large infrastructure projects, and comes with that large disputes, right? So I know one of the questions related to Latin America, I think Latin America is also one of the next frontier in international arbitration, and also litigation funding. These countries are usually civil law countries, so they don't have the prohibition against, in common law against litigation funding under the old English champerty and maintenance doctrines. So you see a lot of countries like Brazil, Peru, Mexico, where there's increasing use of litigation funding. I think Omni itself has opened an office or operation in Latin America, I think this year or last year. So are the other major funders, and there's a reason for that.
Matt, do you want to give us a quick overview of the office that you have open in Latin America?
It's more of an operation than a physical office, but it's covering all of those those areas. We have an international reach. Obviously, we're an Australian company, and we've touched on areas like EMEA and other parts of the globe, but Latin America is a big focus of ours right now.
Okay. Look, there's a couple of questions on the mechanics or mechanisms of funding, which I'll leave to the end, if I may, because I know people have to drop, but Matt, it'd be good to get your thoughts on those right at the end. But before that, I ask the entire panel. We have a question that I think is potentially interesting, which is that, look, funding has received a lot of criticism, or there are increasingly fewer, as the questioner says, increasingly fewer critics of funding, but there are still some. Which of those arguments do you deem to be with or without merit? Are the arguments against funding meritless? Are people kind of barking up the wrong tree here? I mean, does anyone have any thoughts on this?
I have a lot.
I'll say from the private practice of law perspective, all those arguments against litigation funding are simply nonsense. In fact, the presence of litigation funding avoids and retards the bringing of meritless claims because they just won't make it through. And I do think, leveling the playing field matters.
I mean, you've been involved in third-party funding, or working with funders or working funding cases for a long time. I mean, have you seen any deleterious effects on the legal system throughout that time, or have you seen a positive benefit?
Was that directed to me?
It was directed at you, sorry.
Oh, sure. I only see positive benefits. I see good cases being brought and handled properly. I see no deleterious effects, none. Again, with the caveat that we're dealing with the competent litigation funding firms in the commercial space, and I'm not talking about the consumer level at all.
It truly is. Sorry, the alignment that Roman started it, I think we've all now said it. It is the alignment of interests. And if you have that frank discussion at the beginning and align your interests, I agree, it's only positive.
Excellent. Look, I think we should probably wrap up there. I mean, notwithstanding the questions we have got on the mechanics of funding, I mean, Matt, you addressed those at the outset. But if anyone is interested in hearing more or kind of wants to understand how funding works, how can they reach you, Matt?
Well, I hope my contact information is somehow posted as part of this.
Yeah,
but
it is. And I'm sure that goes to the rest of the,
maybe I should just say Google is a good way to contact me.
Literally everybody's available through Google. So if you do have questions on whether you want to work on a funded case or want to ask questions, I'm sure the entire panel would be happy to address those. So look, thanks to everyone for joining. Real pleasure hearing your thoughts. Really appreciate it. And thanks to you in the audience as well for such engaging and stimulating questions. And yeah, all it remains to say for me is a huge thank you, and the video will be up online shortly. But huge thanks to Omni Bridgeway as well for giving us an overview of third-party funding. Thank you.
Thanks, everybody.
Thanks, guys.
Thank you.